Today, I present to you a distilled journey through time, capturing the pivotal junctures in the development of codified law. While charting every intricacy of this expansion would be a phenomenal task, I will instead spotlight key landmarks that have shaped the architecture of modern legal systems. This exploration aims to serve as a robust scaffold for deepening your understanding of the intricate tapestry of laws, codes, regulations, and governance that underpin society. Please note, the following overview is broad brush. It sketches the paths trodden by legal systems worldwide, primarily those rooted in the Western canon, while also acknowledging significant legal traditions from other cultures. This timeline is not an endorsement of historical events or legal developments, but an objective lens to examine the complexities of legal system shaping and adaptation. It is especially pertinent to remember that the proclaimed victors often write history, and as such can obscure the narratives and injustices faced by subjugated or colonized groups. To lay the foundation, let's define a legal system. A legal system is a structured framework of laws and rules together with the institutions and procedures responsible for creating, enforcing, interpreting, and applying them within a sovereign jurisdiction. This system governs the behavior of the members of a community, state, or country, and provides mechanisms for resolving disputes. Legal systems ensure social order, protect individual and property rights, and provide the means for social control and the administration of justice. Fundamental elements of a legal system include constitutional law, the foundational principles and norms of a country, often written in a constitution which outlines the structure of the government, the distribution of powers, and the fundamental rights of individuals. Statutory law, written laws enacted by legislative bodies at both the national and local levels. Regulations, rules made by executive departments and administrative agencies, which have been granted such authority by the legislature. Case law, common law, law that is based on the outcomes of former court cases and judicial decisions, which set precedents for future cases. Civil law, law that deals with the rights and duties of individuals, natural or legal persons, toward one another. Criminal law, law that deals with conduct considered harmful to society as a whole, and which provides for punishments such as fines, imprisonment, or other sanctions. Procedural law, rules that govern how courts process civil and criminal matters. International law, a body of rules that nations consider binding in their mutual relations. Legal systems are typically categorized into major groups. Civil law systems, systems that rely primarily on written statutes and codes as the primary source of law. Common law systems, systems where case law and precedents play a critical role in legal decision-making. Religious legal systems, systems where the legal framework is based entirely or in part on religious scriptures. Customary law systems, systems where customs guide legal decisions, often in conjunction with formal statutes. Mixed or hybrid systems, systems that encompass elements from more than one of the aforementioned types. Each legal system varies significantly in its processes, principles, and philosophic bases, and reflects the history, culture, and political realities of the jurisdiction it serves. Ancient times, c. 2350 BCE, the Code of Urukagina, not fully codified or extant in ancient Sumer, is one of the earliest known law codes. It sought to achieve order by enshrining laws socially, relaying them publicly, and making them universally applicable. c. 2050 BCE, The Code of Ur-Nammu, created in the city-state of Ur in Sumer, is one of the earliest known law codes that has been discovered. It includes laws about slavery, personal injury, and divorce. C. 1754 BCE, Babylon's king. Hammurabi commissions the Codex Hammurabi, which is one of the oldest deciphered writings of significant length in the world. It includes laws covering criminal and civil matters. C. 13th, 15th century BCE. According to biblical accounts, the Ten Commandments are given to Moses on Mount Sinai. These form a foundational set of ethical principles in the traditions of Judaism, Christianity, and Islam. The exact date of the Ten Commandments is subject to debate and varies based on religious or scholarly interpretation, but they are generally placed in the second millennium BCE. The Ten Commandments are considered more a moral or religious code rather than a formal legal system, but they have had an undeniable influence on the development of legal systems in societies influenced by Judeo-Christian ethics. Classical antiquity. C. 7th century BCE. Draco, the first recorded legislator of Athens in ancient Greece, created the Draconian Constitution, implementing a written code that is publicly available and characterized by severe penalties. C. 621-597 BCE. Solon, an Athenian statesman, introduced democratic reforms, including the abolition of debt slavery, and was responsible for the creation of many civil laws. C. 5th to 4th centuries. BCE. Classical Roman law begins its development. The Law of the 12 Tables was produced around 450 BCE, which serves as the foundation of Roman law. Middle Ages. C. 529 to 534. The Byzantine Emperor, Justinian the Wine, orders the creation of Corpus Juris Civilis, body of civil law, a collection of significant works that systematize Roman legal thought. Modern times. 16th to 17th centuries. Development of national legal systems in Europe after the Middle Ages, partly inspired by Roman law. 18th century Enlightenment thinkers like Montesquieu and William Blackstone influenced Western legal thought profoundly with the idea of laws as a system of rules based on natural rights. 19th century, the Napoleonic Code, 1804, presents a clear and accessible code of laws for France and influences many other civil law systems globally. 1870s. As part of the Meiji Restoration, Japan adopted a legal system combining European legal doctrines, including the German Civil Code and the French Penal Code. 20th century to present. 1900-1949, China's legal system underwent successive transformations, reflecting various ideological influences until the establishment of the People's Republic of China in 1949, resulting in a mixed socialist civil law system that continues to evolve. 1920s, 1930s, Soviet legal theory influenced several communist states, creating a system where the law was subordinate to the Communist Party. 1950s, 1980s, decolonialization led many newly independent states to adopt and adapt the legal systems of their former colonial powers, resulting in various hybrid systems. 1980s present. Legal systems adapt to new challenges presented by digital privacy, intellectual property, international law, cybercrime, and the implications of a globally connected world. 21st century, ongoing harmonization and globalization of laws through multinational treaties and agreements, such as the European Union's body of law and international trade agreements. This is a very broad and high-level summary, with many complexities and local developments passed over due to the global scope of the topic. These points could be vastly expanded upon to provide a more in-depth history of legal systems worldwide. Study to show yourselves approved.